Hello, everyone, and welcome to the June 24th iteration of the 2026 webinar series. Thank you for taking the time out of your busy schedule to join us. Before we begin, I'd like to note that the webinar is being recorded and all presentation materials will be posted on our website. If you would like to ask a question, please use the Q&A feature, and if time allows, our speaker will jump into that at the end. I'd now like to introduce you all to today's speaker, Maria Panichelli with McCarter and English LLP. Thank you.
Well, thank you so much for that introduction, and thanks to everyone out there joining us today. As you heard, today we're going to be talking about unlocking the secret to successful debriefings. My name is Maria Panichelli. I am a partner in the government contracts group at McCarter and English. McCarter is a full service law firm. We've got about 400 attorneys spread across, I think we're up to 12 or 13 offices at this point. But my group is the Government Contracts and Global Trade Group, and we focus exclusively on that. I am on the contract side of things and focus my practice on kind of claims litigation, bid protest, and small business procurement. But I kind of run the gamut in terms of helping my clients who are of all different sizes, all different industries, working all over this nation and as well as abroad, with pretty much everything that comes up during the procurement process. For those of you who have been in this world for a while, you know that covers all manner of sins. So not only the protest and the claims litigation, but things like subcontracting and various compliance concerns, terminations, OCIs, debarment, Buy American concerns, cost concerns, False Claims Act concerns, Service Contract Act, etc. Obviously, right now, a large part of my practice is helping advise clients on changes coming up as a result of the Revolutionary FAR overhaul, and we're definitely going to touch upon that today, but also talking to them about things like the proposed rule changing the 8A program, social disadvantage, and other executive orders like the DEI order, etc., that are changing things. Within the small business realm in particular, I do a lot of eligibility analyses, size and status protests, joint venture, mentor protege, teaming agreements, helping folks figure out how to structure mergers and acquisitions in a way that will, not destroy small business eligibility and things like that. So I run the gamut. Like I said, I help clients through every stage of the procurement process. I'm a frequent speaker and writer at GovCon events, and I've probably met a number of you at events for this group, whether it was under the former moniker of the 8A Association or the current group, and might even have met some of you at the Alaska conference a couple weeks ago. But with that, I want to kind of dive into the topics here. If you've got questions, you can feel free to kind of pop them over to me as we're going. I will try to answer those that I can as we're kind of midstream, but we do have a pretty limited amount of time today. So if there are questions, and I will be also, I should say, leaving some time at the end, or at least that's the goal, to answer questions. But since there are, a number of you on here and we've got only a half hour, if for some reason we don't get to your question, or if you don't like asking questions in a public forum, totally okay. Or if you don't think about your question until you get offline, or you don't have a question until a week or a month from now, you can feel free to reach out to me directly. You'll see my contact information again at the end of the presentation as well. All right. So with that, I want to just real quick touch upon something I mentioned when, talking about the kinds of things that I work on, and that is the Revolutionary FAR overhaul. Many of you have probably heard about it. Many of you might know what it is. Many of you might not totally be sure. And if you're not totally sure, that's completely fair because it's kind of morphed and changed and isn't what a lot of people actually think it is. But generally, what's going on right now is that the FAR, the Federal Acquisition Regulation, which is kind of, for those of you who don't know, the seminal body of law upon which most of our procurement framework is based, along with agency-specific supplemental acquisition regulations. And by that, I mean things like the DFAR, the VAR, the GSAR, etc. That is undergoing a major rewrite right now. And we'll talk more about what that means in just a little bit. But what I want you to be aware of for right now is that there is a current version of the FAR. There are agency specific deviations relating to sections of the FAR. And then there is, at least it started 2 days ago, current rulemaking that's talking about actually revising the FAR provisions themselves. So what that means is trying to figure out what provisions might apply to your particular procurement or your particular contract. And given that we're talking about debriefings, it's most likely going to be more on the procurement side or very recent awards. Is a little bit of a Frankenstein's monster. So we're going to start with what the current FAR regulations say. And then at the end of the presentation, I'm going to talk about, okay, what was in the model deviation text, which then means that that would theoretically be what is in all of the agencies that have adopted a deviation for FAR Part 15's deviation. And the rules that they dropped earlier this week don't yet hit FAR 15. So we're still in that weird middle ground, but between the, what the FAR says and what an agency specific deviation says. And I'll talk a little bit about that more at the end. But what we're going to be covering kind of substance wise is based on the current actually codified within the FAR, not the revolutionary FAR overhaul deviations. That being said, the substance of what we're covering is really not something that changes that much. So it's not like we're covering something that's going to be completely irrelevant, once this is finally revised. And we're going to talk about the little tweaks or revisions that are made when we get to the end. Just a little bit of a preface that pretty much has to be on every presentation you give about any GovCon topic these days. All right, so with that, let's just talk very generally about debriefings, and why you might be getting one. Many of you might know, especially if you've been around in this industry for a while, that it's oftentimes considered a first step to filing a bid protest. The idea is to try to get information, so that you can argue about, hey, I should have gotten that contract. My competitor should not have gotten that contract. And for those of you who aren't aware, bid protests are kind of the basis through which you can, as an actual or prospective bidder on a job, dispute the award decision that the agency made by saying, that they did something in violation of law or inconsistent with the solicitation that resulted in the wrong contractor or contractors getting an award or awards. But I think you need to look at debriefings a little broader than that. And I think the most experienced contractors have learned to look at debriefings larger than that. I think it's not just about preparation for a protest, right? It's an information gathering tool, and it's important to use it to gather information to figure out whether you have a protest. In other words, not just assuming, hey, we're going to challenge this, let's get information to allow us to do it. Because sometimes you're not going to have a valid challenge. And that's going to be a discussion you're going to want to have with your attorney about, the potential success on the merits of your protest and what a win would actually look like. In other words, is it actually going to get you to the award stage or not? If you zoom out and kind of take a step back, what you're really trying to do in a debrief is assess what happened, whether it was justified, and if not, okay, then you've got a basis to protest. There's something protestable that happened. But it shouldn't be a fishing expedition looking for a reason to fight. It should be, looking for what happened, why you didn't get the award, and determining if there is a reason to challenge. And then again, like I said, having a discussion with your attorney about, what the cost benefit trade-off might be and whether you're actually going to ultimately have a chance at the award, even if you win the protest, and whether you even have a good shot at winning the protest. But in addition to that, so, first of all, I think you should look at debriefings in a little bit of a broader capacity, even with regards to protests. But even putting protests aside and kind of putting a pin in that for a minute, the debriefing tool is not something that you can use only when you have lost and you want to try to challenge the award that has been made. The pros know, and the really experienced and really savvy contractors know, you should get one even when you win. And there's a couple reasons for that. Number one, it is always beneficial to get constructive criticism on the people that are going to be grading you in the future, right? Teaches you what you can do better going forward, teaches you, comparatively what they like, what they view your strengths as, and they might not view your strengths as the same things that you think they are. They might think, oh no, like we really like that you do X, Y, and Z. And you're like, oh great. I thought that really like the thing that appealed about our company was that we can do one, two, three, but really it's one, two, three, and ABC. It's good to know that that's another strength, or it's good to know that the agency perceives that as something that really shows past performance or shows technical capability. And I guarantee you, you haven't done everything perfect in your proposal, even if you won. You're going to also figure out room, where you can improve, where there are certain things you could do better and put together an even more slam dunk proposal next time. Also, if you're going to be cynical and pessimistic, if you get your own debriefing, if someone challenges your award, if you are bid protested, you have some more information to go on, and then you can, use that to talk to your attorney to figure out if it makes sense to intervene and be involved in the protest, or kind of defer to the agency counsel or government counsel to kind of have your back. So overall, more information is always better, right? The more you know. So, knowing more in terms of what happened will both allow you to assess if you've got a protest and flesh out and beef up that protest, especially given the new enhanced pleading standards relating to protests. But it will also, outside the protest contest, even if you win, really help you to hone your proposal skills and learn to identify not just what you think your strengths are, but what agencies think your strengths are, what they're really looking at, and how you can do better in your proposals going forward. There are a couple different types of debriefings we're going to talk about today, just kind of in terms of the terminology and the concepts. And as you're going to see, those are pre-award, post-award, and those are obviously based on the timing of when you get them. But then there's a conceptual concept of an enhanced debriefing. In other words, you get something a little extra, or you are able to do a little bit more, and we're going to talk about that as well. But the first, I guess, technical thing I want to cover is when are debriefings required? And we're going to see how that ties into certain other stuff in just a little bit. But again, when you're talking about like, oh, I'd really like to get a debrief on this, whether it's to assess if you've got a protest, whether it's just to learn what you did wrong, but you're not really focused on challenging it, or whether it's to learn what you did right, you're not always entitled to one. And that's something a lot of contractors don't know. I think a lot of contractors assume, and there's kind of a lot of misinformation out there, or a lot of kind of presumptions, or kind of just taking for granted the fact that you get a debrief anytime you lose, or, anytime there's an award made. That is not the case. They are actually available, or required, I should say, a lot less often than most contractors think. Mostly they are available under FAR Part 15 procurements, certain FAR Part 16, so like IDIQ procurements. And if other types of procurements, oftentimes like the, commercial item stuff, incorporate FAR Part 15 procedures, which can itself be a complicated question. And that's it. You don't get them for simplified acquisition. You don't get them for FAR Part 8, like GSA schedule acquisitions. You don't get them for sealed bidding. You don't get them for commercial items if they're just using like standard provisions. Um, and just because you asked for one and got one does not mean it was quote unquote required. Now, for our purposes here at this point in the presentation, where we're just talking about asking for one, that doesn't really matter. If you asked for one and you got one, great, check the box. But as you're going to see later, it can kind of impact kind of the interface between debriefs and protests if it wasn't a quote unquote required debriefing. The other thing to keep in mind is that we're going to see as we move forward on these slides that the FAR very specifically governs what needs to go into a quote unquote debriefing, whether it's pre-award or post-award. Sometimes you will have agency folks that refer to something as a debriefing, and what you are actually getting is something that the FAR refers to as a brief explanation, which is you might not be entitled to a debriefing. Maybe it's a FAR Part 8 or FAR Part 13 procurement, and you're entitled instead to a brief explanation of why you didn't get the award. Even if a contracting officer calls that a debriefing, it's not one. It's actually a brief explanation. They're not required to give you the same level or depth of information that they are for a actual technical quote unquote debriefing under FAR Part 15. And again, that's even if you get that and they're calling it a debriefing, That doesn't help toll the deadlines for the protest as we're going to see. So put a pin in this idea of required versus not required for later. But for now, just, obviously understand that you're not entitled to one probably anywhere near as often as you think you are. So let's assume you are entitled to a debriefing or that you're going to get one. What is it that the government needs to cover? And again, the FAR divvies these up into, what do you get and what do you not get for pre-award, and what do you get and not get for post-award. So pre-award debriefings, you got up on your screen right now. And again, this is the current FAR citation. As you're going to see towards the end of the presentation, they've moved this in the Revolutionary FAR overhaul. So the citation will be different, even though the substance isn't really different. You'll see that you've got on your left, what they have to include, what they have to give you, and you'll see on your right what they don't have to give you. Pre-award debriefings, you're pretty limited in the information that you're going to get. And the first question that comes up a lot of times is, well, when does one get a quote unquote pre-award debriefing? This usually happens when you get kicked out of the competitive range. So for those of you who don't know, FAR Part 15 procurements, sometimes they can either just be made on the basis of the initial proposals, best value trade-off, or, now they've got some additional methods in there as well. Um, or they can say, the government can say, we're not thrilled with any of the proposals we got. We're going to take like the top five. Everyone else is going to get a notice. Sorry, you're out. Do not PESCO. Do not collect $200. You are not in the competitive range. But these five best or 10 best or whatever the case may be that we selected, we're going to enter into previously called discussions, now going to be called under the new FAR negotiations, and we're going to let them revise their proposals and then make a decision on the revised proposals. So oftentimes pre-award debriefings come in when you are kicked out of the competitive range, when you get that notice saying, hey, we're proceeding, with some other people to enter into negotiations and get revised proposals. You're not one of them. You've been excluded. Thanks for playing. See you next time. That would be when you request a pre-award debriefing. And if you get your debriefing at that point, all you're going to get is the agency's evaluation of significant elements in your proposal, and a summary of rationale for why you were eliminated. And then you also have the ability to ask relevant questions about whether source selection procedures or, the solicitation terms were followed, and you're entitled to reasonable responses to those questions. But you see on the right-hand side, you're not going to get any protected information or anything like that, but you're also not going to get really any information about who's left in the running, who's still in that competitive range and up for award. You get a lot more at the post-award stage. And obviously, this is probably the type of debriefing that many of you are more familiar with or have heard more about. This is when the procurement goes all the way through the process and award, or awards, plural, have been made, and you ask for a debrief. Here, you're going to get the government's evaluation of the significant weaknesses or deficiencies in the offerer's proposal, if applicable. And obviously, that's again like if you didn't win, if you're one of the people that's following my pro tip and getting a debriefing, if you did win, then they're still going to tell you what the weaknesses or deficiencies were, but obviously that those things weren't ultimately precluding you from getting award. You're going to get information about the total evaluated cost or price and unit prices, and the total, or I should say overall technical rating, both of the awardee, and of the debriefed offer. So if you are a disgruntled competitor that is protesting someone else's award, you're going to get information about their total cost or price, your total cost or price or unit price and unit prices, your overall technical rating, their overall technical rating, and your past performance information. You're not necessarily going to get past performance information about the awardee if you're a disgruntled competitor. If there was an overall ranking prepared, you're going to get that. A summary of rationale for award, which I have seen be 3 pages of very detailed analysis, and I have seen be a paragraph or, a sentence that says the awardee presented best value for the government. It really depends on the agency, how important the procurement is, how likely they think protests are, how overworked the contracting officer might be, the magnitude of the contract, etc. For acquisitions of commercial products, you're going to get the make model of the product. And then again, most importantly, kind of echoing what you saw on the previous slide, you've got that reasonable responses to relevant questions piece, which allows you to ask questions as part of the debrief. You see on your right the stuff you're not going to get. Again, trade secrets, privileged information, all that stuff is off limits. But you're also not going to be able to kind of use this to get a point by point comparison of the awardee versus the debriefed, the debriefee, I guess I should say, proposal. It's limited in what you are able to get. So I mentioned before this concept of enhanced debriefing. And this right now, again, this is one of those things that we're going to see is kind of up in the air, changing for the Revolutionary FAR overhaul. But as of the current FAR, not to mention the deviations, but the current FAR itself. This is something that came about because for DoD procurements, there was an NDAA years ago that then was followed by a DoD deviation, which then finally was enshrined at the DFARS 215506. This idea that sometimes disgruntled offers who are asking for a debrief are entitled to additional information. And there are really two key components that basically you have access to additional documents like the source selection document, and other things that went into or referred to or used by or created by the source selection committee in making their decision, and also this opportunity to ask additional questions, which also then has an added benefit of tolling the protest deadline. As we're going to see, the Revolutionary FAR overhaul incorporates, good for you if you're into getting debriefings, incorporates some but not all of these enhanced debriefing procedures. So it's going to, if the rule ends up going through, the way it's been proposed, or I guess I should say, if the rule goes through the way the model deviation text indicates the rule might be proposed, you will see that there's enhanced debriefing for all procurements, not just defense procurements. All right, so we're now going to talk about the thing that I've been kind of alluding to, which is the interplay between debriefings and protests. We obviously already know what we talked about up front. This is an information gathering tool. You're using it to try to get information to figure out if anything did go wrong, or if unfortunately you just, got outplayed. Someone maybe just beat you. But if it's not that, if it's, they beat you because it wasn't a level playing field, or the government didn't evaluate people correctly, or there was some sort of, mistake in the solicitation, then that is something that is protestable. And you're trying to kind of pick at that and explore that and get more information about that in your debrief to figure out if you can, launch a protest and if you can win. But the secondary piece where debriefings and protests kind of overlap is the interface or the impact on the deadlines. And I'm talking specifically about GAO protests. Deadlines at the I say GAO and agency, but GAO protests. Deadlines at the Court of Federal Claims. For those of you who know protests, you've got kind of options on where you file. Deadlines at the Court of Federal Claims are a lot more loosey-goosey, but when you're talking about GAO protests, you've got a pretty limited amount of time. And if you ask, this is the pop quiz part, if you asked 100 contractors in a room, what's the deadline to file a protest? At least in my experience, 70% of them would tell you it's, you've got to file 10 days after your debriefing. And they would be right and they would be wrong at the same time, because that is the correct answer for certain types of procurements, but it is actually the exception to the rule, not the rule itself. First of all, and outside of any 10-day rule, if you are trying to protest based on issues in the solicitation, this idea that there was something wrong in the solicitation itself, you've got to protest that way early. You got to get that in while you're working on proposals, basically before the time the proposal is due. But once you put that aside, if you're talking about, all right, I either got left out of the competitive range, or this is a post-award situation and I didn't get the award, the rule then is 10 days from the day you know or should have known the basis of your protest. The vast majority of times, the government is going to argue, and a court or the GAO is going to agree that that means the date of the award. And by that, I don't mean the date that you logged in and saw the award. I mean the date that it was posted, the first possible date you could have known about it. The exception to the rule is that if it was a required debriefing situation, so remember how I said that was going to come back, required debriefing that was timely requested, then it's 10 days from the day of the debriefing. But you've got to again figure out, all right, well, is this a required debriefing situation? And then if so, you have to timely request it, which means 3 days from the date you either got the notice of exclusion from the competitive range, or 3 days from the date you got the notice of unsuccessful offer or notice of award that let you know somebody else get it. Now, remember, I said enhanced debriefings kind of play into this too. When you're dealing with the enhanced debriefings rules for the DoD currently, or the DOW, you've got that ability to ask questions, which means that after a debriefing is concluded, you've got 2 business days to submit additional questions, and then the government's supposed to answer that in 5 days. Your deadline does not start ticking until you get answers to those questions. So you can see how, if it's a non-required debriefing, you basically, as soon as you got the notice of award, like you're in your 10-day period. Whereas if you've got the ability to ask, get a debriefing, if you then, have a couple days to schedule that debriefing, then you have the debriefing, then you have a couple days to ask questions, and the government has a couple days to answer, you end up with a much longer time to put your protest together. These deadlines are very strict, but they can be complicated to figure out where on the timeline you are. And it's really important to work with your attorney up front to figure out where you're there so you don't blow any deadlines. Also, keep in mind that these are the deadlines just to be timely. If you want the automatic stay, which is kind of like that big red pause button on procurement, you actually have to file even sooner. So, best practices overall for debriefings. A lot of times people ask me, should I attend? Should the lawyer attend? Honestly, I think that has a chilling effect on how much information is going to be shared. Unless you're expecting something particularly contentious, I say no. I say prepare with your lawyer beforehand, debrief, no pun intended, after, but you guys should go in without an attorney at the debrief itself. You're more likely to get more information. And it is, again, remember, mostly an information gathering tool. Um, you also want to make sure you approach this, even if you're mad that you didn't get the award, even if you think you're ultimately going to protest. Demeanor and comportment are important. This is a friendly conversation. You should be professional. You should be, neutral. You should not be accusatory. All of those things. If you are given an option, you should always pick a telephonic or Zoom. I don't think in person ever happens anymore, but a format that allows you to have some back and forth conversation because you want to take advantage of that ability to ask questions. You are not always given a choice, however, and if you think that you are going to get a written debrief, you really want to, in order to, take advantage of that opportunity to ask relevant questions and get those reasonable responses, you want to get those questions to the government as soon as possible, ideally when you request the debrief, so that when you get the written debrief, all of your questions are answered. Now, obviously, if you've got the ability to ask questions as part of the, enhanced debriefing process, great, but you're not always going to have that, especially if it's not a DoD procurement, because as you're going to see, the questions part is not something that's getting, at least currently, into the Revolutionary FAR overhaul. So the biggest thing that you need to think about in terms of preparing is the questions, working with an attorney or working with your in organization folks to come up with the questions that are really going to explore the areas you think could have caused the problem. All right, so looping back with our last minute or so to the Revolutionary FAR overhaul. As I said, this is something that's been going on. It started via an executive order last April. Then there was a memorandum. The idea being the government was going to propose deviation text. That was done. Agencies adopted deviations. That was done. We are now entering into the formal rulemaking process, but so far that hasn't applied to FAR 15. You can see a lot of the news on this on the acquisition gov page. In terms of what is changing, not a lot of the substance that we talked about there, but there are a lot of changes. Again, I said they're moving the regs. The debriefing for pre-award is now going to be at 15.2062. Post-award is going to be at 301-1. There's some minor tweaks and clarifications in terms of definitions. They're really not changing anything from the way that stuff works right now. They're kind of just codifying in the regulations the way things have been working for a while. So the idea of, days being calendar days, the idea that the contracting officer can do whatever method they want, which, more and more is written debriefing. And also this idea that if you ask for a pre-award debriefing and you're given the option to take it pre-award or post-award and you delay it, that might impact your protest deadline. The biggest difference is, and I kind of alluded to this earlier, that they are incorporating some of the enhanced debriefing that had previously only applied to, military contracts into the Revolutionary Far Overhaul, which means that it would apply to all procurements. But remember, I said there were two components of enhanced debriefing. The first being that you got some access to additional source selection documents. The second being that you can ask questions. At least as of right now, it's only that first piece that's been proposed to be put into the Revolutionary Far Overhaul. So, this idea that you kind of are entitled to look at certain source selection documents, but not this idea that you are able to ask questions and that tolls your protest deadline. So again, I was trying to keep an eye on the chat and the Q&A box as we were going. I didn't see anything come in. But if you've got questions, we've got like a minute before we have to wrap up if you want to ask them, or feel free to follow up with me. Like I said, I do a lot on debriefings, I do a lot on protests, but I do everything under the sun relating to GovCon procurement law for a variety of contractors. Feel free to reach out to me if there's anything that you can think of that you might need legal assistance on. And with that, I will turn it back over to my most gracious host, unless there are any Q&A or chats that I missed, but I don't think there are any unless I missed any.
Yeah, thank you, Maria. I don't see any questions in the Q&A. Um, well, we have one question now. What's the best way to reach you? Which I see you shared your contact information. So is it correct
I,
that that's the best
yeah,
way?
I would say email or phone, the best way. I'm barely ever on, I guess it's called X now. And LinkedIn I'm on, but you're much better off trying to reach me via email at work or my phone at work.
Perfect. Well, thank you, Maria, for such a great presentation. As a reminder, folks, this webinar recording and presentation will be posted on our website along with all of our past webinars by the end of the day. If you have any questions on our organization, our initiatives, or our upcoming events, please reach out to us at events@nsbgca.org. Thank you all again for joining us today. This concludes our webinar, and we hope to see you next month.
Thanks again. Bye bye.